Afternoon. Welcome to the March 9th Civil Service Commission meeting. May we have roll call, please?
Commissioner Hatamian.
Here.
Devine.
Here.
Gregorian.
Here.
Manukian.
Here.
And for the record, Commissioner Gantis is absent.
Okay, what's next?
Minutes.
Gentlemen,
I move for approval without reading. Second.
can we have roll call, please?
Commissioner Hatamian.
Yes.
Devine.
Yes.
Gregorian.
Yes.
Manukian.
Yes. What's next?
Oral communications.
Okay, discussion is limited to items not a part of this agenda. Each speaker is limited to 5 minutes. Commission may question the speaker, but there will be no debate or decision. I see no cards. Anyone in the audience? I see none. What's next?
Recruitment and examination status report.
Mr. Doyle.
Mr. Chair, members of the Commission, this item is the Recruitment and Examination Status Report. Currently, as you've seen this report many times, it lists all of the specific recruitments that are at various stages that involved with our staff. As you can see, we have roughly a page and a half of recruitments going on at the present. A lot of activity in water and power. With who the analyst there is Ms. Akopian, and surprisingly a lot of activity as well in community services and parks and public works. So looks like Ms. Akopian and Mr. Nersessian are very busy relative to recruitment. But again, the report has the opening, closing dates of each of the positions, the exam dates, and other information. So if you have any questions on this, I'd be happy to try and answer them for you. But this is just a note and file item.
Okay. Any questions? I see none. What's next?
Eligible list established.
Okay.
Mr. Chair, members of the Commission, we have an alternate version of this report. We found somewhat of an embarrassing mistake on the last two recruitments listed, which Senior Electrical Test Technician and Station Electrician Operations Supervisor 1 were both listed as being within the Police Department. The correct department, of course, is Water and Power, and I think you all have a handout indicating such. This report, again, is a note and file item, and it's to reflect the recruitments that have been completed and lists have been established since our last meeting 2 weeks ago. As you can see, we have five lists that have been established. Two of them were open recruitments, two were promotional, and one was promotional and open. See from the one that's promotional and open, we did have quite a turnout in the library assistant position, 238 applicants for a single opening. And this is truly a sign of the times. This is a position several levels below a librarian position, but we happen to have a good number of full-fledged librarians apply. It's our understanding that it's either LA City or LA County has been laying off librarians, so we end up, to our benefit, getting some very, very strong candidates for this position. That process, we did both a written as well as oral boards, and we ended up with a list of 15 candidates. So that was a long process, but here to have a good list on that. The others, again, two additional open recruitments. The next two are somewhat more specialized, both in water and power, in the public benefits charge area, as well as the power planning area as well. And then the last two listed, the Senior Electrical Test Technician and Station Electrician Operator Supervisor 1, those are both positions at the GWP yard. Those were handled on a promotional basis, and we have, again, a list of 2 and 4 on both of those. So if you have any questions on that, I'd be happy to try and answer them.
Sure.
Yes, sir.
Library assistant, 15 eligible names. How many openings do we have? Do we have any?
As of now, we have just one opening. But as you know, these lists are good for up to 2 years. So if we have additional openings in the next 2 years, we'll certainly go back to this list and select names off of that.
Okay.
Fortunately, it would have been nice to have more than that, but
Any other questions? I see none. Next item, we're going to switch things around. We're going to go ahead and bring item number 8. Can you read that in the record, please?
Sure can. Reports and information passed to employee performance evaluations.
Commissioner Devine, you want to handle that for us?
I will. Under no past dues, we have City Manager's Office and City Treasurer's Office, Fire Department, Glendale Water and Power, Library, and Police. So I think that's very good showing. Under first notices, we have, there's 15 employees in several departments that are on first notice with lacking evaluations. And unfortunately, we have one office that appears there's one person that's is on the fourth notice now, and that is the city clerk's office. And I'm wondering whether our city clerk can come up and talk to us about that a little bit.
Certainly, if this is the time for me to make my response. Chairman Manukian, esteemed members of the Civil Service Commission, Commissioner Devine, we do have one very delinquent evaluation that we have to present. I apologize for having to appear here under these circumstances. In fact, the last time I was here was also for late evaluation. That was 5 years ago when I was just elected. Similar circumstances bring me here at this time. We have been in the process of conducting the elections, a number of duties that we're taking on that are new to this process, this go-around. And one of the individuals, actually, we have one that's, I believe, on the third notice or on a second notice, and the other individual are individuals who have special circumstances. One of the individuals took bereavement leave, was not available for the evaluations. There was someone very close to them actually passed away, and we want to give some more time to be able to evaluate that individual. And the other individual's evaluation is completed. I just have not had the time to process it. I know that doesn't seem like an excuse when the HR department is directly across the hall from me, but I can assure you we'll be done this coming week. If not by tomorrow, then by Monday.
Very good. I was wondering, do you have one person that does the evaluations? See here you have 10 employees, so is there one person under you that does all evaluations? What's your protocol for doing them?
The evaluations are done by my assistant city clerk, and I do the two evaluations we each do the evaluations for the employees who report to us. I perform conduct evaluations for the two employees that report to me. My assistant city clerk, Rita Buchanan, conducts it for the individuals that report in the general outer office to her.
Okay.
Mr. Kasakian, with everything that you have on your hands right now, we completely understand, and we appreciate everything that your department does for all the elections out there. So good luck. Thank you for everything that you've done for us.
Thank you, Chairman Manukian, and we assure you that they will be completed in the coming week. Thank you.
You have no doubts about
you.
that. Thank you.
Good luck.
Okay, what's next?
Presentation on the role and function of the Civil Service Commission and employee rights under civil service.
Sir Doyle.
Mr. Chair, members of the Commission, 2 weeks ago at our last meeting, we began this presentation on employee rights and the roles and functions of the Civil Service Commission. And we got pretty close to halfway through the presentation, but because we had a lot of items on the last meeting, we thought it would be appropriate to stop as the hour was getting late and finish the rest of it at this meeting. So very pleased to again continue this presentation. And if my recollection is clear, we had just completed slide 9 and we were about to begin slide 10. Before we do that, though, I want to ask the Commission if there's any questions you have from the previous meeting or anything requiring clarification.
No, I think you did a great job.
Okay.
So we're with you.
Very good. Then we will now begin with slide 10. And as I said previously, this is, I think, a good opportunity for all of us, for some of the more veteran commissioners as well as the new commissioners, to go through these rules, go through these functions and responsibilities, and just to make clear what it is that we're working on here. We'd like to start with again slide 10, which deals with probationary periods. So, And really, as I said before, we going through this presentation, more or less the order that these items appear in the civil service rules. Probationary periods are dealt with in Rule 6, which is the rules more or less coordinate with chapters in each section of the Commission rules. The one having to do with probationary periods starts on page 28, and it deals with the limited role that the Commission has in these matters. But really, a lot of people don't realize that it is the Commission itself that determines the length of the probationary period. In most cases, we have employees in the City of Glendale on a 6-month probationary period. The managerial positions, the police, fire, public safety positions, and a handful of other non-management positions do have a 12-month probationary period. But it is the Commission that makes that determination. And every once in a while, and I would say every year or two, I'll bring a resolution before the Commission determining on the length of the probationary period. And again, the Commission makes that call. Typically, when I'll bring it back is when we have new classifications that have been introduced. I'll wait till the end of the budget year, and if there have been 5 or 6 new classification titles added to our lists, or if some have been eliminated, I'll bring an updated list for the Commission's review. But again, that is handled by resolution, by special resolution by the Commission. And I was just thinking to myself, it's probably about time that I would do this particular resolution. But for the most part, again, that's the function that the Commission plays relative to probationary periods. The employee rights, of course, fall upon the whole issue. They have the right to attend the meeting where this is being discussed. They can get up and speak on the matter. They can object to whatever is being proposed. But for the most part, that's how it works. As you know, probationary periods are very important. When an employee is hired onto a job, they serve in that capacity as an at-will employee for the full extent of the probationary period. And what at-will means is that they can be removed at any time during that probationary period for any lawful reasons. The appointing authority, the supervisor, is not required to show cause or serve the employee with a skelly letter or anything along those lines. There's truly no due process at that point. And the same applies when an employee is being promoted as well. If I'm a police officer and I get promoted to police sergeant, even though I may have been with the police department for 5 or 10 years, in my capacity as a newly appointed police sergeant, I have to serve a new probationary period, and that probationary period is a year.
Now, what happens when you don't, let's say an officer's been with us for 15 years, becomes a sergeant, and for whatever reason things don't work out during the probation period, is that person reverted back to a regular officer, or is that person, how does...
A very good question, Chairman Manukian. That person has what's known as property interest rights to their former job if they should fail their probationary period during the following their appointment to the new position. So, and that's kind of the significance of a probationary period. Once an employee gets through that period, they attain property interest right in the job, they attain their civil service status. Up to that point, they don't have it. So again, in a case like this where someone gets appointed to police sergeant and they're not successful in that new job, then they get returned back to their former position of a police officer.
Okay.
In circumstances of that nature, does it rely on, let's say, the discipline, the nature of the discipline? So is discharge an option and also demotion an option, and that decision relies upon management to make, or is that something that the Commission makes?
Commissioner Hatami, in that situation, if there's if you're saying if there's some cause for disciplinary action or more severe disciplinary action than simply removal or reduction to the previous position, then that department would have to show cause and show appropriate charges and grounds and that employee would have some degree of appeal rights if they're going to be, say, terminated completely. But if it's simply a matter of that employee not meeting the requirements of the higher level job on a job performance basis, then that can be done without any involvement with due process.
It's safe to say if it's a policy violation, demotion, also discharge is an option. If it's a performance-based issue, we're looking at possible reduction.
Yes, return to the former classification.
Got it.
In a disciplinary action, can either the appointing authority or the commission impose a new probationary period as part of a remedy to a problem? In other words, the employee's being disciplined, he's already served probation in that particular position. Now, as a condition of perhaps being reinstated or whatever, can the appointing authority or commission say you're back on probation for X amount of time?
Commissioner Devine, in my opinion, the answer would be no. The employee, again, attains a particular right under both the civil service rules and case law once they have passed probation in a job, and assuming they're returned to that job or they're still in that job, neither the commission nor the appointing authority can impose a new probationary period. It seems like a good idea, and it would be an appropriate remedy to have the employee go through that process again. But legally, I would say I don't think we could do that.
The length of probation, assuming that's going to be is a variable length of probation, is a variable time, or we can decide somebody 3 months, 6 months, 9 months, 1 year, something that's going to be fair, because I'm worried about the fairness.
Mr. Gregorian, all of our probationary periods are either 6 months or 12 months. And I think the way it's worded in the rules, I don't have in front of me, but I believe it says all probationary periods, and I know that it says this on our bulletins, will be 6 months unless otherwise stated on the job bulletin. So the only alternative to that is would be 12 months. And our charter, in fact, there's a provision of the charter which prevents us from having a probationary period any longer than 12 months. So really the choices are 6 months or 12 months. And again, for most of our non-management positions, we go with a 6-month probationary period. We think that's fair and reasonable. And in the course of that, I know the next chapter talks about performance evaluations. In the course of that probationary period, most employees typically get evaluated at least twice. If there's a 6-month probationary period, they'll get one at 3 months and then another one at 6 months. If it's someone who's on a 1-year probationary period, they'll get an official evaluation at 6 months and then another one at 12 months. And again, it's incumbent upon the appointing authority, the supervisor, if they believe they need to fail someone on probation, they need to take action to return that person to their former position, or, again, in the case of a new employee, they need to terminate them prior to the conclusion of their probationary period. If by chance they're not paying attention, deadline passes, and the supervisor walks in and says, doggone it, I meant to fail this person on the probationary period, but here it is, 6 months and 2 weeks later, and I missed my opportunity, can I still do it? And the answer to that is no. They've missed their opportunity. So it's very important. That's why our department spends a great deal of time and energy trying to manage this process and make sure these departments are filling out their performance evaluations in a timely manner, and that particularly in the case of a probationary employee, if there are problems that emerge, myself, my staff, we're working with that department to more or less get them to make their determination as to whether that person passes or not.
I do have one more question regarding probationary periods. During a probationary release, circumstance of that nature where we have an employee who's on probation, whether it's performance-based or policy violation, and they're being... Does DHR state a reason or give them a cause for that release? Or do we completely treat them as an at-will employee and say, well, we don't really have to give you a reason.
That's a good
We're just being let
question.
go.
That's a good question.
Commissioner Hatami, that is an excellent question, and the answer to it is we typically do not give a reason. We typically do not give cause because of the at-will status. When you begin listing reasons, then that more or less opens the door to the individual may have a perception that they would have the right to appeal it, and from a legal standpoint, it just doesn't make sense to give cause when you're not required to do so. So typically the only reason we give in those circumstances is that you've essentially failed to meet standards of this position, period. And it sounds harsh and cruel, but you got to understand, during the probationary period, it's the only point in someone's employment in public service where the city, the employer, the appointing authority has all of the leverage and all of the freedom to make a call on that individual, because once they do pass probation,
That's it.
the rules change completely, and it becomes substantially more difficult to take that type of action. So.
The only reason I bring up this issue is just to play devil's advocate. You have circumstances where certain employees feel as if that they've been retaliated against, and so therefore they're being released during the probationary period. Ultimately, cause can either be given to the employee, where you give them a probationary release and you state the cause for the release, or you can simply have an internal document which protects, in turn it ends up protecting the city because you document the deficiencies of the employee, hence giving you a valid reason for the release. So whether it's something that goes external to the employee where they understand the cause of this release, or it's an internal document, and I'm just bringing this on from personal experience dealing with some of these things. At-will employees, generally we save those for, like student workers, so on and so forth, from my understanding. When somebody's on probation, and legal counsel may chime in any time, from my understanding there's still some interest, even though they're on a probationary period. Therefore, if there's any deficiencies, we usually have the supervisors document these deficiencies continuously, hence kind of substantiating or validating the cause for the release.
Is that still during the probation period?
It's
referring to?
Yeah, during the probationary period, if there's deficiencies, there's performance issues, policy violation, whatnot, the supervisor documents, and then there's a probationary release process, and it's either internal or external. But ultimately, it goes on both sides. Yeah, the employee is able to see what the cause for the release was, or you can make it be an internal type of a document where if they later on decide to sue, even though we consider them to be at will, it's still a valid lawsuit. They're going to hear it out to see if you're claiming a Rule 25 violation, which is discrimination, retaliation type of a circumstance, it's still going to get heard. And so if it's a performance issue, it ends up protecting the governmental entity. So I was just wondering, has that ever been brought up?
Yeah, Commissioner Tommy, it is. And again, these types of situations are done, they're done with the full involvement of the HR staff, and there typically is documentation. In many cases, there's an evaluation will have been served, as I said.
That was going to be my question.
And that type of documentation can be relied upon, as well as, a supervisor may have, internal notes and files and things like that. And you'll note when I introduced this item, I said, an employee can be released for any lawful reason during the probationary period. I didn't say any reason in the world. If someone decides, I don't like this particular ethnicity, or I don't like people over the age of 60, I'm going to fail them on probation, then you're absolutely right. I mean, that would expose the city to liability, and even though that person may not have appeal rights internally, they can certainly go out and get a lawyer and say, hey, the city discriminates. But this is handled very, very carefully. And again, our our requirement is that if this is going to happen, then they'll have to involve someone from my office to oversee it and make sure that it is handled properly and that all things are properly documented and anything given to that employee has the right verbiage to it, so it doesn't create problems for us in the long run.
Yeah, I guess my concern was mainly documentation. So long as there's documentation to...
So just to clarify, if I understand, and that was a very good question, by the way, make sure that I understand correctly, the way I take it is, if there's issues and somebody's going to be terminated, let's say even during the probation period, you still go ahead and document it just the same way as you would any other employee, even if they were after the probation period. But the only thing we don't do is during termination, we don't give them a reason why. That's correct?
That's correct.
So the other performance issues would still be documented correctly, no matter if they're during their probation or past. Okay.
Correct.
Mr. Doyle, and I suspect that individuals are also counseled. They're given an opportunity to correct their errors. So, for example, if someone's hired with a condition to have a Class B driver's license and they don't, then they're given an opportunity to do that, and all of that is communicated to the employee.
That is correct. And again, that probationary period is so important for both the employee and the supervisor. It's the period of time when we expect and we demand of our managers that they spend a lot of time with on-the-job training, discussing what their goals, what their expectations are for that particular employee. There needs to be a lot of communication. Outside of that probationary period, again, we encourage ongoing communication between the employee and the supervisor, but during the probationary period, we insist upon a lot of it, and that's the only effective way to make this work. And again, we do take it very seriously, and any decision to release an employee is not treated willy-nilly. So.
Okay.
The
Question.
next,
Yes.
I'm sorry, I have to ask a very rough question.
not at all.
Yes. In our city, with this diverse population and people, has it ever occurred that we did have a practice any kind of a conspiracy situation that in a department, couple to three people, working against a newcomer in order to create an environment that to give him a hard time not to pass the probation period?
Commissioner Gregorian, I would hope
I
nothing
told
like
you it's
that.
a kind of rough question, but so considering the fact that our different people who are
living in our city and apply for jobs and those kind of things, so
That would,
I would
in my, very good question, but I would hope all this time that we dedicate to this commission and all the people that, I would hope that is not the case. But that's a very good question, and God help them if they do.
Yes.
Because
Again, it's
if all of us are dedicating all this time and volunteering to this commission, it's to avoid situations like that. And I hope that's not the case. And I'm confident that's not the case.
well, my message is to public and community that we are, every one of us over here,
Absolutely.
sitting down here to see and observe that everything is just going the right direction.
Absolutely.
Because out there, lots of people, so many, of our public members asking questions, and sometimes it's very difficult to answer to that questions. Thank you very much, sir. Thank you.
okay. The next slide, and we're still talking about probationary periods, and this is a somewhat important function that occurs, and this is addressed in the rules. The extension of a probationary period. I've mentioned already the charter has limitations on how long a probationary period can be. It can only be 12 months, no longer than that. However, an employee can, or not an employee, an appointing authority, supervisor, manager, can request to extend an employee's probationary periods. And there's really two circumstances where this would be applicable. One would be if the employee is on some form of a leave, where they're either out on a workers' comp injury, they're out on some type of a long-term illness, it might be a pregnancy, something along those lines. And, you know, it is the entitlement of the appointing authority, the supervisor, to have a full 6 months, 12 months, whatever it may be, period of time to evaluate that person. If somebody starts and in their second month they get hit by a car or something like that and have to be out for 3 months, then you know, it's incumbent upon that department to notify my office and request to extend that probationary period. Let's say that individual is out, is going to need to be out for 3 months. Well, we would pretty automatically grant that type of an extension, and that's pretty routine. And so you know, we would just simply take those 3 months and tack it on, and once the person comes back, they would serve what would amount to a normal probationary period. The ones that get a little more sticky are those that involve performance-related issues, and this really only applies in the case of 6-month probationary periods. Periodically, and I won't say it happens all the time, but I'll get maybe a half a dozen of these requests each year. A department will be approaching the individuals the end of their probationary period, and they'll simply ask for more time and say, you know what, we haven't had the opportunity to observe or fully observe this person doing all of the essential functions of this job. Could we extend it 2 months, or can I have another 30 days or another 3 months? And those occur, like I said, maybe a half a dozen of these each year. And those requests go to me, and typically I'll listen to what their circumstances are and either grant it or deny it. If it's a situation where you know, someone is just clearly not meeting the standards, but the department just doesn't have the heart, you know, to terminate them on probation, in many cases I'll advise them to go ahead and fail them on probation. If it's a situation where let's say the supervisor may not have been around, or you know, they just haven't had the ability to fully evaluate that person for the needed time, and there's some other extenuating circumstances, then I may grant it. And you know, a good example might be, let's say a firefighter gets assigned to a very slow station, hasn't had the opportunity to go on a big fire or a big emergency scene or something like that, and you know that department may say, you know what, we really haven't been able to see this person in action. Can we extend it? In that type of a situation, I may go ahead and do it. So, but anyway, those are circumstances that come up occasionally, and really that decision rests with me, and somewhat unusual, but this is one of the few cases where a decision made by me can be appealed to the Civil Service Commission, and that's written right into Rule 6. If a department requests an extension and I say no, and they disagree with that, they would have the right to come here and address the commission and ask that the probationary period be extended in those circumstances.
But the employee can't.
Correct.
Commissioner Devine, you had a question?
I do. When you make that decision, are both parties there? Do you have the employee and the appointing authority to hear both sides of whether or not it should be?
Commissioner Devine, no, sir. Remember, the employee is the one on probation here. The employee doesn't have a whole lot of leverage. This is a decision largely made upon the request of the departmental management, and it really isn't up to them to determine their probationary period. Once that decision is made, they are notified of the extension. And again, it's my job to make sure this isn't just being done arbitrarily, that there truly is good cause for wanting to extend that probationary period. And I like to think I put a lot of serious thought into that decision. Okay. That's probationary periods, and again, it's a very important element of really our jobs. We all know once someone passes their probationary period, they do accrue a great deal of rights that don't exist during the probationary period. Okay, next up we're going to talk about job performance evaluations. Performance evaluations, as you know, are a very key element for not only providing feedback to employees on a regular basis, but also it's really key area of communicating with employees, and also goal setting for the employees, telling them, giving them the things that they do well and things that they don't do so well. If you have a situation where you have an employee who's having job performance related problems, and somewhere down the road you may end up having to take disciplinary action or even termination or demotion or something along those lines, we would expect there to have been some prior documentation in the job performance evaluation. So, job performance evaluations are addressed in Rule 7, and there's not a whole lot here. It does, the actual section in the rules is more instructive in nature, and it talks about the process of giving it to an employee, and it talks about the employee rights, and there's two very important rights when an employee does receive their performance evaluation. They are asked to, once they receive it, to sign it, but the employee does have the right to refuse to sign if they happen to disagree, and in those cases the appointing authority or the person giving them the evaluation would simply write, "Employee saw this evaluation, however, refused to sign it," and that's acceptable under the way the rules are currently written. In addition to that, the rules do indicate that the employee has the right to rebut the evaluation or to attach comments to it. And how that is done is typically they're given 3 days following the evaluation, and the employee can think about what their comments are and things that were said, and if they disagree with them, they have every right in the world to go ahead and write comments either rebutting the evaluation in whole or various parts that they may disagree with, and that's certainly a right that they would have. With regard to the Commission's authority, there's nothing in the rules about this, but several years ago, and as you're all well aware, the Commission did establish an internal policy to really monitor the timeliness of these evaluations, to make sure that they do get served in a timely manner. And the Commission asked us to set up a structure where if the evaluation is late, if 30 days late, that they're notified of essentially that becomes a first notice. If that goes on a second month, that becomes a second notice. And if it goes on beyond that, there's a third and a possibly fourth notice. And as we saw earlier today in the meeting, we have department heads appear if there is a third notice or beyond. So anyhow, but that's an internal Commission policy, and I think it's one that's been quite effective, frankly. And it's unfortunate Mr. Gantis isn't here, but this did emerge while he was on the Commission, and Mr. Coleman and Mr. Carrion both had a great deal to do with this provision. And really, it came out of some of the civil service disciplinary appeal cases that we had, where the Commission's opinion, they had observed that individuals being disciplined were either not being evaluated properly or not being evaluated timely. And once again, if a department is going to demote someone, fire someone, take some form of disciplinary action against someone on the basis of job performance, well, it's just effective management to make sure that those areas are addressed in the performance evaluation, and that those performance evaluations are done in a timely and an effective manner. So, again, that's really the role that the Commission has adopted, and like I said, it is the right, and I've included it in the slide, that the employee does have the right to receive job performance evaluations in a timely manner. And again, if an employee is not getting that, they can come here and address the Commission on that.
Yes.
Couple of questions. On the first part, we have to slide back. You kind of explained how the history of why the commission's involved in the evaluation timeline and whatnot. Up until I heard that, my feeling was that it was really a management problem, not a commission problem. In other words, if department head or appointing authority is not getting the evaluations done in a timely manner, to me that should go up through levels of management, be resolved at that point. And even with your explanation as to why the commission got involved with it, I'm wondering whether this might be something that the new commission, newly constituted commission here, can revisit and find out if it's really something that we want to continue doing. I have concerns about it. Quite frankly, and I'll use today as an example, I really saw no purpose or gain by bringing the city clerk in and asking why one evaluation was late, 4 months late. To me, that could have been much more effectively handled by management talking to him and saying, we need to get this done. Pardon me?
I agree with you.
So, and to me, I just don't think it's an effective way of dealing with it. You mentioned that it was, but I think management, even if Starbird or Mr. Starbird or Ms. Beers has to actually get in there and get them done. But that's just an observation, and perhaps, Mr. Chair, we could agendize that item and revisit it.
We could.
If we have a...
We could. But I have a little bit different take on that. I think, when listening to Mr. Doyle, and when he mentioned that there's been previous issues where other employees have had been demoted due to performance issues, and during those hearings, it was they found out that, for example, the evaluations weren't done in a timely manner or they weren't done correctly. I think that's why probably we have this. But again, this is something that we can talk about.
And I agree with you, and I understood that point, but my take on it is that
what we do with it is not really
effective. It's not the department head's fault for not getting them done. It's management's fault for not following up with the department head. And we really should have the manager, the city manager in here maybe. This is an example to find out. So anyway, it's just a concept, a little different take, and perhaps we
can always fine-tune things. So.
Yeah. The other question I had, and I'm
Could I comment before you go on to the next item on that?
Okay.
I just want to say we could certainly revisit that, but I do want to say what I was giving you was sort of the origin for why this came to the attention of the commission. I agree with you completely. This is a management issue and something that we ought to be able to resolve without the intervention of the commission. I will say, however, it has been effective because it has put some teeth into the process. I can contact a department head and say, hey, you have late evaluations. And we have always managed that process. I have Debbie Mallon and Salpa Jagaspanian are absolutely on top of this process completely. And I, frankly, in a lot of my networking, other cities and professional organizations, I know of no cities that do it as thoroughly as we do. But it does become more effective at actually getting it done in holding the department heads, their subordinate managers accountable for this particular function when there's the threat, I should say, maybe that's not the best word,
oversight.
But when they know that they might have to come and explain themselves in a public forum, that's been a somewhat effective tool in making sure this occurs. And it's not that this commission has ever been involved in, scolding these department heads or anything like that. But I think it's just the idea. It's just that one little extra, piece of accountability that, is in the backs of their minds, saying, gee, I'd really hate to have to go to the commission and, explain myself. And I think you all noticed it. It doesn't happen very often. We don't get many of these, and it's because I think, frankly, department heads don't want to be here at 5 o'clock.
This is the first one that I saw.
But anyway, that's just my take on it, and we can do this effectively either way, whether it's me putting down the hammer on departments, the city manager, or if the commission wants to remain involved. But that's...
Well, maybe we can resolve this. We already know how Mr. Gaddis is going to feel about it, since he's the one that instituted it. We've heard Mr. Manukian's, Chair Manukian's position. I don't know, Mr. Dorian, whether you feel, after what you've heard, it's still worthwhile to revisit it. We haven't heard from Mr. Atani.
I actually had a comment and a question. I actually want to thank Matt for kind of setting up the process that you've set up. In a smaller city type of an environment, what we do is basically our supporting documentation when we impose discipline, promote, whatever we do is a performance evaluation. So to have some oversight to ensure that the PEs are being done on time, I think that's an important thing. Ultimately today, yes, we did have a department head that came in here, and the question was in my head, but I didn't really pose it. We really don't know if this employee whose PE is overdue missed any promotional opportunities or was in any way harmed because we had this time lapse between the Ps. And I understand that they're very busy, and I understand the resources of the city, and we're shorthanded, and that's with most governmental entities. I completely understand those things, and that's maybe why I didn't pose the question. But PEs are such, in my opinion, such a critical function of what we do, because they're supporting documentation in, when we have to impose discipline, that's what we look at. And so when they're not being done, it just takes a lot of ammo out of our, ability to impose or even promote. And I'm talking the two extremes. And that's my comment. One question I did have to Mr. Doyle is regarding the PE process itself. It's my opinion that we have a rater and a reviewer. Is that how it works with the city of Glendale, where we have somebody that rates, and then we also have a reviewer that reviews the rater? Is that correct? Or how is the system set up? And I don't want to divert from what we're talking about, and I can revisit this question so we can kind of put this to rest, whether or not we do want the PEs, we do want oversight over the PEs, and then we can jump into that.
Well, based on what I've heard from what I know is going to come from one commissioner and the other two, I think it's something we're going to probably not have to revisit. You've made some good points.
Thank you.
So I would let that one rest. I do have one more question, though, on the evaluation that I'm confused about. You gave your explanation, Mr. Doyle. You indicated the process where the employee gets the evaluation, and then he has a right to question it. And I believe you indicated he can write a report or write his concerns and submit them. And you didn't go beyond that point, though. And then I see on the board that the commission or the employee has the right to attend commission meetings to address his concerns. Are those the concerns about the timeliness of the evaluation?
Yes, sir.
Or are they concerns about his concerns about the evaluation?
The context of the slide relates to concerns about the timeliness of the evaluation.
It's my understanding.
The content of the evaluation and differences of opinion between the employee and the supervisor is not within the purview of the commission.
Can you expand a little bit, though, on that explanation you gave where the employee does have a concern, he writes it and presents it to somebody? What happens after that?
That's a very good question, Commissioner Devine. Essentially, the employee has the right to write a rebuttal of any sort, and they serve that, or they give that. Serving sounds so official, but they give it to the supervisor, and they also provide it to Human Resources. And when the evaluation gets filed in the employee's personnel file, the official file within the Human Resources Department. It will contain both the original evaluation and that individual's comments. So it serves merely as a rebuttal for anyone who reviews that personnel file. They'll see both the evaluator's comments and determinations as well as the rebuttal.
And that rebuttal lead to possibly having the rater change an item in the report or in the evaluation, or is that the end of the line? Or is there a grievance procedure? Let's say he files his concerns and the rater says, well, I still feel the same way. Can that be grieved in any way up through management?
Yes, Commissioner Devine, very good questions. The rebuttal can initiate changes certainly if the evaluator recognizes that, hey, I got something wrong, or hey, I failed to remember this great project you worked on or this great accomplishment that occurred, then they certainly can go back and write those elements back into the evaluation and serve it a second time. Those are the things I would hope that would be dealt with while the evaluation is being served and discussed, and that is part of the process, is that we want to make sure that the supervisor has a private meeting with the individual and sits with them and goes over it with them. It's not the situation where they simply hand it to them or email it to them or something, or text it to them. It's supposed to be by policy, and all of our training programs and our supervisor manuals talk about this being an interactive dialogue. And if the supervisor misses out on something or forgets something, it's certainly within his or her authority to fix it and change it. If there's such a difference of opinion on various aspects of it, we will allow a grievance to be filed. The grievance, however, has to be based upon any factual differences or any factual inaccuracies contained within the evaluation. It cannot be based upon a disagreement of one's job performance, and that's unfortunate for the person who feels they're getting evaluated unfairly. But really, it is the job of the supervisor, the manager, to make those calls, and from a subjective standpoint, if I evaluate one of my employees and give them meet standards, and they receive it and say, this isn't fair, I think I'm outstanding, and we sit there and argue back and forth, that's not something that that employee is going to be able to grieve. Now, if I give an employee an evaluation, it says you're getting meet standards or you're getting a below standards because your attendance is poor and you had 125 sick leave hours, and it turns out it was only 35 hours. That's a factual inaccuracy, which is subject to some review, I think, in a grievance process where they can essentially get to the bottom of it. So again, the grievance could apply when there are factual disputes, but if it's just a general disagreement in how the individual is rated, we wouldn't support a grievance on that.
Where is the end of the line in the grievance procedure? Where does it stop?
The grievance procedure starts with the supervisor, and if it can't be resolved at that level, it would go to the department head. If it can't be resolved at that level, then it would go to the city manager's office. Typically, it's
that's the final word then.
That is, yes.
Appeal to that?
No.
Okay.
Did I answer everyone's questions on performance evaluation? Okay. All right, then we'll move on to the next slide. This would be in Rule 9 of the Civil Service Rules, which is a chapter that relates to transfers. Commission is somewhat familiar with transfers. We get these periodically. Just to give a broad overview, there are really 4 types of transfers. Well, actually, there are more than that. There are about 5 of them, but the most common are transfers within the department. In other words, if I'm the Director of Public Works and I want to transfer one of my civil engineering associates from the engineering section to the project management section, I can do so pretty much without any permission or authority or anything along those lines. The next level would, and that I would call an intra-departmental transfer. The interdepartmental transfer, where someone essentially moves from one city department to another in the same exact classification, that can be handled administratively as well. With really, it requires the cooperation of both department heads, but essentially moving a person from one department to another in the same classification is an interdepartmental transfer, and that's done administratively with our office's approval and the approval of the city manager's office. It's when you get to the other types of transfers that the Commission gets involved. And again, I think you've seen some of these in the last few months, where you have either a similar qualifications transfer or a lower qualifications transfer. Those do require Civil Service Commission approval, and those are typically dealt with in closed session because oftentimes they'll involve the employee's personal desires as to why they want to change or move into a particular job assignment. And I think it's been asked. I believe it was Mr. Devine, and correct me if I'm wrong, even on those types of transfers, why do those even need to come to the Civil Service Commission? And the easy answer is because it's in the rules. But I think at some point, many years ago, the idea was that there needed to be some oversight to ensure if someone is taken out of one job title, put into another, that there's some appropriate oversight to make sure that people are placed appropriately in a classification for which they qualify for, and that it doesn't get so flexible or to where these types of trades or transfers are made with little oversight. So, but these are fairly common. You get several of these each year, and a lot of times it'll happen when a person's job functions change, and we need to come up with a new classification title, something either more specialized or less specialized. In fact, the one that comes to mind immediately was taking, I think it was 3 administrative analysts who specialize in the budget and transferring them into budget analyst positions. Again, it was a move made to ensure, or truly to recognize the specialized nature of that particular work. So that's really the extent of the Commission's responsibilities relative to transfers. And as I said, it's happens occasionally, and the employee, of course, does have the right to come and not only make the request of the transfer, but also the right to appear before the Commission and speak on their own behalf when a transfer does occur. Any questions on that?
Whenever you have just one question on, when you have 2 employees, they're not getting along, and one complains about the other, whether that's a Title VII complaint or just a disciplinary issue, does a transfer of that nature happen automatically, or does it come before the Commission?
If it's a transfer, like we take an employee in one department and we decide from a managerial standpoint it's best to separate employees and take someone and move them to another, that would not have to go before Commission. That can be handled administratively. Okay, next we're getting into the infamous Rule 10, which deals with disciplinary actions, appeals, and hearings. And I imagine you have a lot of questions or concerns over this particular area. But you know, the whole issue of disciplinary actions, obviously, very sensitive area of our work, as well as you know, a very important function for the Civil Service Commission. Once again, the disciplinary actions, appeals, and hearings are addressed under Rule 10 of the Civil Service Rules, and I'll kind of give some prefatory comments about what occurs when someone does get disciplined. But essentially, there are two stages in the disciplinary process. One is the predetermination Skelly stage, and the other is the post-imposition or the post-determination imposition stage. And it's the post-imposition of discipline stage that the Commission gets involved with. But when an employee is being subject to disciplinary action, the appointing authority and the department management is required to obviously put a case together where specific charges and grounds are addressed, and that employee is presented with that proposed disciplinary action in the form of a letter. That letter is called the Skelly letter, and it gets its name from a case, a California Supreme Court case that occurred back in 1974, which essentially set the framework for disciplinary actions within the public arena. But this letter is served to the employee, and it basically, by law, it has to it requires various things. It has to tell the employee what proposed disciplinary action is going to be taken against them, whether it's a one-day suspension or a one-week suspension, a demotion, a termination, a mandatory employee assistance rehab program, anything like that. It also has to inform them what the effective date of that suspension or disciplinary action will be, and it has to lay out in very clear language what rule or policy that individual violated. And you'll note from Rule 10 of the Civil Service Rules, a lot of those charges are listed within the rules. And then the proposed action has to discuss in very plain language what the employee did to warrant this disciplinary action. And it would have to say, on March 13th, 2011, you were observed making inappropriate comments to a fellow employee. And the details thus have to be contained within that letter. And so all of this is laid out in the form of the letter. And that letter also gives the employee their notice of their rights to predetermination appeal. In the city of Glendale, that employee has the right to talk with their department head, and also they have the right to appeal that to the city manager's office, similar to how a grievance is handled. Those are what's known as the predetermination hearing stages. An employee is served with this letter, they read the letter, and generally their first action after that is to call Mr. Hinckley or whoever their employee association representative is, if that person is not already there in the room. But and then their next call is typically to both the department head and to the city manager's office, indicating that, hey, I'd like to meet with you on this proposed disciplinary action. And that process takes up to a few weeks. There's typically some scheduling issues where the employee tries to get in with their department head and the assistant city manager, and ultimately in this predetermination hearing stage, the city manager and or the department head can do one of three things. After they've listened to the employee and met with them, they can either uphold the proposed disciplinary action, or they can modify it to some degree, or they can choose to throw the whole thing out if they feel that the case wasn't made properly, or if that there was some form of an explanation or excuse or something along those lines. So that's what's known as, again, the predetermination hearing stage. Once the city manager's office makes their determination, they then notify that employee. And if it's their decision to uphold the disciplinary action, then that disciplinary action is imposed by the department head, and they serve them with a second letter, and this is known as the final notice of disciplinary action. And this is what actually makes the action take effect. If it involves a termination, that person becomes separated from employment. If it's a demotion, then that actually occurs. The final notice of disciplinary action does inform the individual of their right to appeal the disciplinary action to this body, the Civil Service Commission. They have 5 working days to appeal to the Civil Service Commission, and typically that's done in the form of a letter. They'll notify my office and either come by and drop off the letter with either my secretary or myself, indicating that they intend to appeal the matter to the Civil Service Commission. And at that point, we notify we notify the employee of the next scheduled civil service appeal hearing, at which point that hearing officially opens, even though that first meeting is typically just the meeting where a lot of the housekeeping is done as far as setting dates and determining open versus closed hearings. But the charter does require that once an employee does appeal, they have the right to the hearing occurring within 2 weeks, and that's why we're typically in such a big hurry when we do get that appeal, to make sure it does get on the next Civil Service Commission appeal, or next Civil Service Commission regular meeting. So it's at that point then that the commission is charged with hearing the case, and typically the chairman will appoint a subcommittee, and that's provided for within the rules. And there are various options for hearing a case. Our tradition has been for the commission to appoint a subset of the full commission to hear a case. Typically on a termination case, that will consist of 3 commissioners. If it's a lesser form of disciplinary action, including a demotion or a light suspension, the chair of the commission can appoint a single commissioner to hear it. Whether it's handled by 1 commissioner, 3 commissioners, or the full commission, the ultimate decision is made by the full commission. If it's heard by one member or 3 members, those members, once they conclude the hearing, they'll have to report back to the full commission, and the full commission has to make that determination. And I forgot to mention another option, is that the commission can farm this out to a independent hearing officer if they want to, for one reason or another. If they feel there may be a conflict of interest, or because of workload, if there's, I hate to say it, and I don't want to put a curse on this, but these disciplinary appeal hearings kind of come in waves, where we'll have none for months upon end, and then all of a sudden we'll have 5 or 6 of them all at once. And when that occurs, you folks are going to be very busy. But in those cases, you can retain the option of having an independent hearing officer, some type of an arbitrator or judge or
We have
somebody.
done that?
The commission, not to my recollection. Not to my recollection. The city manager's office has, if they feel that they've been too involved in a case and the discussion thereof, in the predetermination hearing phase, they might hire it out to someone else. But in my recollection, I don't think the commission has ever done that. I can keep talking if you want to, interrupt me or whatever. But basically, you're all somewhat familiar with the handling of these hearings. The commission has that initial meeting with the appellant and the appellant's counsel and the appointing authority who represents the city. We always provide counsel to the commission. Lately, we've used Mr. Harold Potter, who's very good at the administrative end of things. The employee does have the right to have this heard either in an open format or a closed format, and I will say probably 95% of the time they will choose a closed hearing, in which again it's just handled by the commission staff, the respective counsel, and the various parties who are directly affected by the hearing. But in the case of an open hearing, it is absolutely open to anybody who wants to walk in off the street. We do not televise those, but we do publish the agenda in an open format, and really anyone can walk in and observe the proceedings. And there is the potential for, I suppose, all kinds of things. Someone bringing in a video camera, tape recorder. I don't want to give anyone ideas, but it could end up on YouTube or something like that. So it's
Great.
The open hearings can be a little bit challenging. So anyway, tried to cover a lot on the issue of discipline in the hearings, and ultimately, at the conclusion of the hearing, the Civil Service Commission or the subset of the commission will report to the full commission what their recommendation would be. The full commission can do in-depth analysis of what the subset of the commission has recommended. They can listen to the tapes or transcripts from the hearing if they want to get that level of detail, and ultimately, whatever the commission is comfortable with in making a determination, it again has to be voted upon by the full commission. The decision of the commission at the conclusion of a hearing is final and binding. There's no appeal beyond that, other than to Superior Court. The parties could choose to file a writ of mandate 1094.5, and that has been done as well. But again, that's the only alternative to any aggrieved party at the conclusion of a hearing. The appellant cannot appeal to the city council or the city manager or anyone else at that point. It has to, if they want to continue on with it, they'd have to take it to court. Questions?
From my understanding regarding the writ, once a writ is filed, the court can actually shoot it back to the commission for reconsideration sometimes. So even though it leaves here, and correct me if I'm wrong, counsel, it can still come back at some point if the court decides to revisit certain issues and have the commission reconsider things. And I'm just bringing this forth from things that I've experienced with LA Superior Court, where LA County commissioners will make a decision. If management or the employee disagrees, goes across the street to Superior Court, and sometimes the judges will look at certain things in a different light and shoot it back to the commission and bring those things to light and have us reconsider certain things. Does that ever happen, or has that ever happened here?
I can't speak to that. I don't think that it has happened here, has it?
Commissioner Hatami, it is not. In my career here, I recall maybe 4 or 5 cases that had gone to a writ, and none of them have ever been directed back to the commission to rehear anything. But not to say it can't happen. I imagine a judge can do a...
General Tamia, we are doing much better job than Los Angeles.
I don't doubt it. But at the same time, there are certain things that, come up. And when you're dealing with a certain number of employees versus a larger number, a lot more things happen. So it's not a matter of the job that's done, and I respect your comment. It's just a matter of a larger quantity and more issues and more diversified issues. So it has come up and it does happen. It's just that sometimes, like I said, when it does go to Superior Court, a judge is going to look at it in a different way than a hearing officer or 5 commissioners. And sometimes it has happened where it gets shot back to the commission and they say, well, we want you to do a review on this specific issue. and they'll narrow down the issue for the commissioners just to look at.
I know one case that I'm aware of that in fact, that's happened, not here, not in this city, but exactly what you're talking about. You're absolutely right.
I do have one question regarding the Skelly process.
Mr. Hitami, could I interrupt you?
Sure.
We just, with this issue of the judicial review is actually addressed in the rules, section 11B, and it does indicate after a writ has been filed, it says if there's no provision for reconsideration of the decision, this is at the top of page 44, it says if there's no provision for the reconsideration of the decision, an applicable provision of any statute, charter, or rule for the purposes of this section, the decision is final on the date it is made. And the next, number 3 says, if there is such a provision for reconsideration, the decision is final for the purposes of this section upon expiration of the period during which such reconsideration can be sought, provided that if reconsideration is sought pursuant to any such provision, the decision is final for the purposes of this section on the date that reconsideration is rejected. Clear as mud, huh?
How many times?
You lost me at what?
The term reconsideration comes up often. So, I mean, it's a big circle. And this truly comes from experience. I've had it where it's shot back to the commission for them to reconsider. It does happen. Wow. So reconsideration is definitely an option when you file a writ in Superior Court. It's just I was wondering whether or not that's happened with the city of Glendale, and ultimately just to shed some light on the issue that does happen. It just creates additional duty for us to really scrutinize everything that comes into play, because ultimately, the burden is so high that if we make a decision, it may end up in Superior Court where a judge may review it, and if they disagree with that decision, it's going to get shot back to the city to reconsider certain issues. So that does happen. But my question was more geared towards whether or not it's happened here.
And if I may, I think that generally comes up if there's an abuse of your discretion or if you haven't considered a material fact. I think that's probably why we haven't had that issue get reverted or sent back here for reconsideration.
Yeah. But it does exist.
Yes.
Just a quick question. I'm sorry, were you through?
Yes.
Okay. You mentioned the formation of the panels of 1 or 3. Is there anything that prevents a 2-member panel from hearing? In terms of you want an odd number, so there's...
Commissioner Devine, no. The rules are silent on specific numbers. It's largely at the discretion of the chair and, I'm assuming with the concurrence of the commission. But again, the rules indicate that the entire commission may hear a case, or it can be a subset of the commission. But it doesn't express a preference for odd numbers over even numbers. We typically do the odd numbers in case there's, I guess to avoid a tie and the complexities associated with that.
Okay.
One quick comment regarding the Skelly process, and this is just more towards the viewers, citizens of Glendale, and also the employees at large. The Skelly process itself, I think the nature of it is just to have a separate Skelly officer who's gonna, and it could be a manager, that's separate from the facts and comes in there, and pretty much the employee, if they're being disciplined, has the opportunity to present their side of the story, or possibly facts that the manager who's imposing the discipline hasn't considered. For the city, is that the case where if we have a Skelly for an employee who's being disciplined, do they have the opportunity to have a Skelly officer that's completely separate from the unit in which they come from or the department that they come from?
Commissioner Tommy, no, the employee is not given the choice of who the predetermination hearing officer would be. It would have to be either their department head or again the city manager's office. And we do make provisions if the city manager, typically it's the assistant city manager who is the predetermination hearing officer in that office. If he or she is aware of the case or involved in the decision, somehow been involved in a meeting where this was discussed, then in those cases, we would assign it elsewhere within the office to somebody, perhaps the deputy city manager or the assistant to the city manager. We take pretty extensive measures to separate people. In fact, I've had many meetings where department head and myself will be pondering a disciplinary case or an investigation, and we'll want to have some input from either someone in the city manager's office, and we'll make sure that we better not invite this person to that meeting because they may end up being the predetermination hearing officer. But we have not given them the opportunity to say, go to a department head of another department to hear their case, somebody within their own department.
Yeah, I think my question or comment was more geared towards not giving the employee the choice to choose who they want to have as a hearing or a Skelly officer. And the reason why I bring this up, and I bring this forth to the commission panel, ultimately the Skelly process is a buffer zone where the employee has the opportunity to have an independent party who's not part of the investigation, the fact-finding process, or the decision-making process to make a determination whether or not the employee, what they're presenting, has any credibility. So it's somebody that's independent. And what that does, it separates the individuals who are involved with that employee, whether it's at a management level, unit level, to really hear out the employee and give the employee a fair shake. And I'm not saying that that does not happen, but it's a buffer zone. If that process is, I can't say perfected, but if it comes close to perfection as possible, what it does, it creates an opportunity for the employees to really be heard. And definitely for our workload purposes, at times, if you have somebody who's separate from the facts, we'll sit there and really listen to the employee. However, if you have individuals who are part of the same unit, there may be political pressure, there may be whatnot, where this individual may not reduce the employee's discipline.
And that's a very good point. But my question, Mr. Doyle, isn't it been, I mean, at least based on my experience previously on most of these cases, the only officer has either been the assistant city manager or it's not been somebody directly involved in their unit, correct?
That's correct, Chair Manoukian. Let's be clear, the hearing officer, the predetermination hearing officer is the city manager. In this organization, it has been delegated to whoever is serving as assistant city manager or deputy city manager, and on rare occasions, the assistant to the city manager. The option to see the department head is, even though they have the ability to overturn or modify the action, they are not officially the predetermination hearing officer. The city manager's office is. And as I said earlier, our efforts, I mean, we're a large city, but we're also a small city. We have a small city manager's office. Given that, we've taken some painstaking efforts to try and segregate whoever that hearing officer is going to be from any involvement, discussion, decision-making relative to that case, because we don't want them to be tainted. We want them to have an open mind and be able to look at the proposed action with a critical eye. And I'd say they traditionally in this organization, they've done a good job at that. And Mr. McFall, who retired a year ago, did this role, held this function for close to 20 years, and he was very hard. He was very harsh on the appointing authorities, and I think he took the role of the predetermination review to a level that I don't think existed before, and it became more than just a simple review to ensure that due process was being afforded, but in some cases, he would re-examine, facts, and he would call people in, and so he kind of set the tone for that. And Ms. Beers does an equally good job in doing that. And the bottom line is, just to make sure that the employee believes they have a fair, they're being heard, a fair process, and that even if it does get upheld, that the opportunity to express their views and have the matter reviewed by an independent entity. I have to say, and you can talk with employee association representatives, that the process has worked pretty well.
I think mainly that's why, the issue was brought up by me, but give some reassurance to the employees.
Absolutely.
And also the citizens that when they're going through a Skelly and they're being heard on the issues and they're disclosing facts, that they have somebody independent that's going to give them a fair shake. Ultimately, you can appeal it to the Civil Service Commission, but if you feel as if though you're getting a fair shake and you have somebody who's completely separate from the facts, there's no political pressure on them, they're going to hear you out and ultimately give you a fair outcome. Follow-up, and I'm going to be very brief, is does the Skelly officer obtain counsel from the city attorney's office or anywhere if, for example, if issues come up, questions come up, or if they want to reconsider the discipline, whatnot, do they have the ability to contact outside to get in more information?
Commissioner Hatami, yes, they do. They have those resources available at their disposal. The hearing itself, the meeting itself, they try to keep it fairly informal, really for the benefit of the employee who's going through the process. So there is no counsel present at that time, even if the employee does bring in an attorney, which typically does occur in some cases. But if there's a question of legal precedence or whatever, they will have the ability to contact the city attorney's office or even myself or a member of my staff who again, may or may not have been involved in prior decision making on this.
Thank you for that.
Sure.
Okay. Going on to the next one.
Okay. So the next chapter, and this would be Rule 11, deals with a number of different areas: layoff, resignation, and reinstatement. I'll kind of hit the highlights and just a couple of the things, the main areas of this particular chapter. The layoffs is a pretty significant function contained within the rules, and layoffs are largely governed by the Charter. And interesting, the Charter provides a really open framework for the establishment of civil service, and it's Article 24 of the Charter that addresses civil service. But in all these matters, whether it's discipline, transfers, the Charter basically sets forth the framework and leaves it up to the civil service rules to put the details in on the various elements of these functions, and within Rule 11 of the Civil Service Rules, it does talk about layoffs, and really the process for having layoffs is addressed within the rules, and it doesn't say a great deal about how it is supposed to work, other than the fact that layoffs are to be based on seniority and overall service time with the city. When the city does have a situation where funding problems, budgetary or otherwise, we have to lay employees off, then there's a whole process that gets set forth where the department has to submit the name. We have to make sure and look to see if that individual has seniority over other people within that same classification throughout the city. They do have rights to bump those individuals and set off essentially a chain of events that gets to be a real headache. But it's a process that I think most traditional civil service systems have that would more or less protect those with the highest levels of seniority in the case of a layoff. But essentially, if an employee does get laid off, their name is placed on a layoff list, and it's just like an eligibility list. In fact, Rule 5 of the Civil Service Rules addresses the order of list utilization. It'll say layoff is always going to be the number one list that you would have to go to first, and then you'd have to go to promotional lists, then a reinstatement list, and then an open list. But it's very important if someone does get laid off per Civil Service Rules, we do require that individual to be hired back should an opening occur within the next 2 years of that person being placed on the eligibility list. Similar to other lists, the employee gets placed on a layoff list for up to 2 years. And if the 2 years does expire, the employee does have the right, and that's one of the things I've listed on the PowerPoint, they have the right to request that their name be extended on the layoff list beyond the 2 years, and the Commission can grant that request or deny it. Layoffs are not something that are pleasant, obviously, and again, it's a process designed to affect people on the basis largely of their seniority and the amount of service time they have with the city. So that's essentially how layoffs work. If you have questions on that term, or we can go on to the next slide.
Okay.
Okay. Next slide, slide 16. This is also part of Rule 11. Deals with reinstatement. And this commission, I think most of you are familiar with the reinstatement process. Essentially, when an employee leaves, they resign from the city or separate from the city, they do have the right to request reinstatement within a year of their date of separation. And essentially, the employee can do so, or the former employee can do so. They have a form that they can fill out. It pretty much addresses when their start date was, their separation date, and we bring that before the commission, and the commission gets to consider the reinstatement of an employee. And I'll remind you, it's the commission's action that places the employee back on the list for that particular position for which they left. There may not be an opening for that particular position, so placement of the employee's name or the former employee's name on the list is something that's authorized by the commission. And as you know, we do this in closed session because oftentimes issues of that employee's job performance are brought before you. I think we provide the last three performance evaluations, so you can look to see what kind of an employee this individual was before making that determination. Obviously, again, that's a very important right of an employee or a former employee, and their ability not only to apply for reinstatement, but to also appear before the commission and give their request to be returned to city employment. Okay, any questions?
We're good.
All righty. The next slide, I talk about subpoena because I think in any discussion of the Commission's authority, I can't let it go by without reminding you that you do have the right to subpoena individuals to appear before you. And typically this is done in the context of a hearing. But forgive me, I didn't review exactly what the rules say on this, but it is a important power that the Commission would have in the context of a hearing. If you don't think you're getting the full story, or if there's a particular witness you believe you need to hear from in the course of that particular disciplinary hearing, you can issue a subpoena, and we'll make arrangements to have the individual served. And very, very much similar to, I think, in the context of a hearing, we'll have either the appointing authority or the appellant request to have either individuals subpoenaed or we have the subpoena ducis tecum process where particular documents can be subpoenaed. All that is done under the authority of the Commission. So that was a very important element within most of your hearings. Questions on that? Well, looks like we're down to the last slide, and this is again a very, very important function of the Commission, and that is the ability to amend the rules. And this is a process which we engaged in most recently, last few months, and we did amend the rules for the first time since I believe it was 2005. Was the previous rule amendment, and really we try and do this periodically every 5 to 10 years, just to make sure the rules are contemporary, they're meaningful, they're up to date with the latest case law, and I think this last go around we did a lot to really improve the rules and make them a little more contemporary. And I was at the executive staff meeting this morning with city manager and the other department heads, and the city manager asked me to sort of go over what changes were approved in this latest round of the rule amendments, and I discussed a few of the items and things that I thought were important and beneficial to that our department heads needed to know. But really, for the most part, a lot of it was just cleanup. But again, this becomes an important function of the Civil Service Commission. Again, the power to amend the rules, change them, and have them established as well. And again, it's a partnership you have with the City Council. You approve the rules, or you vote on the rules, and City Council does have to approve them. I said to you at our last meeting, this went before the City Council last night, and I am happy to say this latest round of amendments were approved easily. And they certainly appreciated the work that the Commission did. Saved them from having to go through these one by one. They had other things to discuss last night. So, again, back to the format of the presentation. We talked about the Commission's the power to amend the rules, as well as I want to talk about employee rights. And it is important that we're dealing with any type of rule amendment that substantially impacts upon the working conditions of our employees. We do have an obligation to meet and confer with our employee associations. And I think if you'll recall, when we were considering these rules, we have the employee associations here at various points. I had many discussions with them at both bi-monthly meetings we've had, and I think they were all very much engaged in these changes and didn't see any particular concerns with them. I mean, as a matter of standard policy, that's typically the relationship we have with our employee associations anyway. But again, it's a process that if you're going to make substantial changes to any type of rule, policy, MOU, there is the obligation to meet and confer with the employee association. And once again, for the employees' rights, they certainly, when the Commission was considering rule amendments, they have the right and the ability to come here and express their views on that, as they did last night when it appeared before City Council. There was no one here for that, but they had given their 2 cents when it was brought before the Civil Service Commission. So that pretty much concludes our presentation on this. I do want to thank you for really some just outstanding questions, really, which made me ponder a few times. But I do think, having gone through this exercise, I think we're all a little more educated on what is the role of the Commission, as well as what rights our employees have within this system. And I want to thank you for your attention, your outstanding questions, and Chair Manoukian, I want to thank you for suggesting that we do this to begin with. So,
Well, we want to thank you for putting on an excellent presentation. I know with everything that you guys have to do at the office, I really appreciate you guys doing this, and I think I speak for my fellow commissioners also. Okay, what's next?
Agenda forecast.
Mr. Doyle.
Mr. Chair, members of the Commission, the agenda forecast, we have one item for the next meeting. I'm assuming we will have some specifications and perhaps job bulletins for your consideration. I know we're in the midst of some hearings as well that will be starting around this time, but the report we have for our next meeting have to do with a discussion that Commissioner Devine initiated on class specifications, and have circumstances where there are minor revisions. Can that be done administratively? Rules be amended administratively to address those. So we will come back with, I'm sure, a brief report on that. Perpetian.
I'm wondering if we can change the date of that, because I won't be here at that meeting.
Chair?
Planning on doing this via conference?
I doubt it.
Yeah, I guess so. Let's move it to the next one. So the 13th, correct?
That would be April 13th.
April, correct.
Again, we anticipate some of the more routine tasks relating to class spec approval and bulletins and any others that require your action. So,
Okay, sounds good. What's next?
Civil Service Commission and her staff comments.
Any comments? See none?
Mr. Chair, I
Yes.
just wanted to reiterate the last night, and I mentioned it earlier, but last night the City Council did approve the Civil Service Rule amendments, the latest round, and so we will be incorporating them into a new book, and hopefully have a new cover and publication, and we'll make sure to hand it out to all of you and make sure it gets on the website in a timely manner. Right now, we were dealing with the version that had cross-outs and underlines and things like that, so we'll need to modify those, and we'll have a nice publication. Looks like I need a new one, because this one's about on its last legs. So anyway, look forward to that, to getting that to you shortly.
Sounds good. Okay, what's next?
Adjournment.
Thank you, we're adjourned.